The broadcast is now starting. All attendees are in listen-only mode.
Hello, this is Jennifer Schautz, and welcome to our third week of government contracting webinars. Today we're joined by Christopher Shiplett, who's going to be talking about bid protests. So we're excited to have him here today and hear about his insight on the 5-item go, no-go checklist. All of our webinars are complimentary and they are recorded as well. So in the event that you miss one, you can certainly download them from our website under the webinar section. The full list of the schedule of webinars is also listed on our website at that same spot. A little bit about us. We're based in downtown DC and provide various services for federal contractors all over the world. We service both product and service companies, domestic companies, as well as foreign, providing services such as market analysis reports, capability statements, proposal writing, 8A certification, GSA schedule help, and contract administration. We host various webinars, seminars, and events throughout the year. To stay abreast of those, you can sign up for our newsletter under the Contact Us section of our website, or you can just go to our website and click on the event or webinar section. A little bit about me is listed on this slide, but more importantly, I'd rather talk about Chris Shiplett and his background, and then we'll dig into his topic. So thanks everybody who was able to join us today. Again, the webinar is being recorded. The recording will be posted on our website later today. So Chris, thanks again for joining us, and I'll give the floor over to you.
Sure. Good afternoon, everyone, and welcome. Thank you for joining what over the next few months is a very topical subject, I believe, which is bid protests. A little bit about myself. I'm the founder of Randolph Law, which is a small law firm that specializes in government contracts law and other law for government contractors, regulations, teaming agreements, contracts, and stuff like that. Prior to going to law school, and actually during law school, I was in law school at night. I worked as a database administrator for a series of small government contractors on contracts for the Army and the Marine Corps. So I'm familiar with not just kind of the high-level legal stuff, but the day-to-day stuff that you guys in the government contract world go through. You can take a look at more about that on these two pages here, and more about what our firm does and that type of thing. I think what I'd really like to dive right into is our topic for today, which is bid protests. And Jennifer, if you don't mind going to the next slide, and we'll sort of introduce the topic and go from there. We're here in the third week, I guess, of August. And as you all know, we're getting to the end of the federal fiscal year, and contracts are starting to fly out the doors left and right. Maybe we have a couple more weeks, maybe 3 more weeks before we really get going with contracts. But the kind of the ramp up to the end of the fiscal year is coming. And contracts flying out the door left and right means bid protests coming back in left and right. What I'm here to talk to you about today is sort of a 5-item list. These are not necessarily the only important items that you need to think of, but really 5 things to think about as you are trying to decide whether to protest a decision that your company has not been awarded a contract, or your company has been eliminated from consideration for a contract. Part of the usefulness of having this type of checklist is really to simplify what I would call a wave of incredibly complex information that you get. You know, if you were to call me and say we had a notice of award that somebody else received a contract, you're going to be inundated with just a wave of incredibly complex information, all of which will bear on your ultimate decision of should I protest. So, well, and I guess the other thing too is that protests are not a zero-sum game, meaning the end result of a protest is not a winner and a loser vis-a-vis the contract, which increases the complexity of the information you are asked to digest when you're trying to decide whether to protest or not. So I've put together kind of this 5-item checklist. It's just 5 high-level things that I think can guide you in your decision. The first one and this is not a typo, I've written it 3 times out here, check the deadlines, check the deadlines, check the deadlines. If any of you have been involved in a protest before, you know that the deadlines are very, very fast. I will tell you that the deadlines are even faster than you think, because there's probably protest opportunities that you've missed because you didn't even know that there was a deadline. Let's talk about really 3 different types of deadlines that you need to be aware of. The first one is that any protest to GAO or to the Court of Federal Claims, which is another venue for protests, that is based on the terms of the solicitation has to be submitted before the due date for bids. And I want you to make that very, very crystal clear. If your complaint is about the terms of the solicitation, you have to protest before you even submit your bid. Now, what are some of the examples of something like that? Well, if you think that the RFP is really geared towards one particular potential awardee, and so therefore you think that the terms of the RFP are written narrowly to make it easier for that awardee to win, you have to protest that before your bid goes in. If you think that the solicitation includes onerous contract terms in it, for example, I saw one recently where you would be terminated for default, sort of the contractor's kiss of death, for a minor defect in delivering a particular piece of equipment, you have to protest that before the bid goes in. So that is the one key deadline. Now, to remember. Now, there is really an entire process for figuring out if you want to file a pre-bid protest. The specifics of that process are really outside of the scope of today's discussion, but there is that process. It starts with reviewing the RFP. It goes through the formal question and answer period, as well as the informal and other formal steps you can take to clarify the solicitation before you submit your bid. But the real key is that is the #1 deadline that I see people missing. They call me up, they've received a notice of award. When we start talking about what's wrong, it turns out what they're really complaining about is the terms of the solicitation. They've already missed the deadline. Another big deadline is, and it's this third one down here, this different timeline for different acquisition types. Many people who've gone through protests are familiar with the process. You receive your notice of award. You have 3 days to ask for a debrief. You receive the debrief, and then you can protest up to 10 days after the debrief. Here's a key, though, is that that's only for FAR Part 15 acquisitions. FAR Part 12 acquisitions, which are commercial items, and FAR Part 8 acquisitions under the GSA schedule don't have those deadlines. And most importantly, the government is not required to give you a debrief. So what does that mean? Well, that means if you have a FAR Part 12 acquisition, your deadline starts ticking the day you get the notice of award. You're going to submit an email asking for a debrief. The government's going to send back what they're sort of calling a debrief, but they will know that it's actually a, quote, short and plain statement of the basis of award, and they'll also know that the deadline doesn't kick off after they've submitted that. The deadline has already started when you are awarded, when you receive the notice of award, which means if they wait until 11 days to send you that document, that email or what have you, and you say, oh, I've got 10 days from now to start my protest, you're already too late. And the third category of protest deadlines that are very important are what I'll call non-technical protests. These are protests that aren't necessarily going to GAO or to the Court of Federal Claims. If you're protesting that a contract was set aside for a small business or for a socioeconomically disadvantaged small business, but it was awarded to a company that is not small, if you're protesting the HUD zone status of a company, or if you're protesting the NAICS code that is assigned to a particular solicitation, those have different deadlines. They're not based on debriefs, and you can't go to the GAO for them. You actually go straight to the SBA for those protests. The most important one of those three is the NAICS code protest, which the deadline starts ticking from the date the solicitation is issued, which means if you get to award, you realize you're a small business and another business that you don't think is small was awarded the contract, but you think the contracting officer was playing games with the NAICS code, you're way, way, way too late. And finally, final note about the deadline in technical protests is that although there's a 10-day deadline, if you want a stay of award, you have to adhere to a 5-day deadline, which is actually a 4-day deadline because the deadline is when GAO talks to the agency. So just be aware, very, very tight deadlines. I've spent a lot of time on item 1 because it is by far the most important item. We're going here to item 2. The second one in the matrix is how good was your proposal really? And let me give you 2 brief examples of this. The first one, I had a client I spoke with recently where the PWS in the solicitation talked a lot about the qualifications of the employees and resumes that were submitted. The company said, well, we think that the acquisition wasn't done right. We're ready to protest. There's no way this other company had better experience than us, better people, and a better solution. I said, take a Microsoft spreadsheet and match up a matrix of what you submitted in terms of your people's quals and the required quals. And the company did that. They realized that they hadn't submitted qualified people, right? That's kind of the second bullet point here. Sometimes the government's right. Had they decided to proceed to the protest, they would have wasted their money because they did not submit a qualified bid. So you should be doing your compliance check and your matching up of your proposal to the terms of the statement of work and the solicitation well before you submit the bid. But a last check in deciding whether you want to protest is marking this up and making sure that you're not going to be embarrassed when you submit a protest and allege that the government's made all of these mistakes when you yourself have made all of these mistakes as well. Third item here in our 5-item checklist is check the issues. There are different issues that have different likelihoods of success. GAO does not like to substitute its own judgment for the agency's technical judgment, which means if your claim is that the agency's technical evaluation was poor, or they misevaluated you, or they misevaluated the awardee, you're going to have a lot more trouble than if your issue is a simple yes/no one. If, as an example issue, you believe that the awardee submitted their proposal late and that the solicitation said the government absolutely will not consider late proposals, right? Or you believe that the government conducted discussions with only the eventual awardee when they were required to conduct discussions with everybody. Those are the types of issues that are much more simple than a straight technical evaluation. Even more difficult than the technical evaluation, and I bring this up, it's D here on this slide. You know, everybody thinks that the contracting officer was against them, and everybody is probably right about that. But those types of allegations that the contracting officer or the members of the selection committee really put their thumb on the scale intentionally in order to award the contract to their preferred vendor, those are very, very, very serious allegations that GAO effectively has said we won't even consider them without a mountain of evidence, right? So a lot of times when we go in and somebody says, you know, I say, well, what's really happened? And they say the contracting officer put his or her finger on the scale. We say you can't allege that. You can allege that they made a mistake unless you have some sort of email where they say they despise your company for personal reasons. You're never going to get that. So check the issues. Some issues are easier to approach GAO with than others. And it's not a go, no go just on this. It's really just how easy is it going to be for GAO to see your argument and reverse the acquisition decision, or for the agency itself to see what you're saying, reverse the acquisition decision. Let's take a look at the next slide. The fourth item here would be check the agency and the acquisition type. And let's kind of walk through this one a little bit because this is very important. And we're actually going to go from the bottom up on this slide. The last item there, some things are not protestable by statute and by regulation. A task or civilian task order award of under $10 million evaluated price, and a DOD or NASA or I think Coast Guard within Homeland Security task order award under an IDIQ of under 25 million is not protestable on 99 out of 100 grounds that you would submit to protest it. So what does that do in terms of your go, no-go decision? Well, your protest is going to get kicked out if you protest one of those acquisitions pretty much immediately. Really what that should do for you is change your response strategy from the get-go, right? On the kind of the negative side, the side where the lawyers come in and protests are, you can't protest it generally. On the positive side, you may be able to take risks in terms of what it is you're proposing, knowing that if you're the awardee, it's protest-proof from somebody else protesting. So certain acquisition types are generally non-protestable. Now, you know, the lawyer in me says they are protestable. There are grounds that you can protest, but the short and plain statement of the facts on 5 items me says, for the purposes of this presentation, you're not going to be able to protest those. Certain agencies are more likely to reverse an acquisition decision. I can think of a couple agencies specifically that are known through scuttlebutt to be easy protesters, meaning you protest and they just accept everybody who's protested back in. The other thing is that certain acquisitions are easier to protest. A lot of protests I'll see are large IDIQs, and this kind of wraps back into certain agencies are more likely to reverse. But thinking on large IDIQs, in many cases on the government side, is, well, you know, let's let them all in because we know that some percentage of the awardees aren't going to pursue any work anyway. And really an IDIQ is just a tightening of competition. It's not necessarily the actual acquisition decision. So make that part of your consideration. You know, if it's a large IDIQ, perhaps you want to go ahead and protest because it may well be that the agency you know, just lets all the protesters in. A couple notes on that, one that I'm thinking of and the other that's right there on the slide. The first one is the converse to that is if you bid on a large IDIQ, and by large, I don't mean the dollar value, I mean a lot of awardees, right? It's a 50 or 100 awardee IDIQ. If you bid on a large IDIQ and everybody else who loses protests and you don't protest, you're going to be left in the cold because the agencies won't always take a bunch of protests and turn them into a decision that affects non-protesters. They'll just, well, take all the people that protested, let them in, and that'll get rid of their protests. We can move on to the actual work we're supposed to do. The other piece is that to some extent, whether a large IDIQ is easier to protest than, say, just a straight one-off contract depends on the potential protest grounds. It also depends on the language in the solicitation. If you go back and there's several draft versions of the solicitation, and it seems pretty clear through all the drafts that there's an absolute limit on how many companies the agency's going to allow to hold contracts. They're less likely to let more people in. If it's clear that they're going to pick the top X percent, then it may be more likely that they'll let people in. Another one, and I ran into this spring with actually a series of protests, is it depends on the protest grounds. If your protest is, for example, on a process ground that the agency kicked you out because this was an actual case, when they looked at a list of the documents included on a DVD, they didn't actually look at the documents. They just looked at the names. Agencies aren't likely to just let you all back in and have to redo kind of their process based on that. So a lot of times it'll depend on the grounds, but the takeaway from this is that the agency that's conducting the acquisition and the type of acquisition itself can impact the viability of a protest. One other item I'll mention on that I have not put on the slide is between best value and lowest price technically acceptable solicitations. There are vast differences in the way a protest will proceed, because for an LPTA, if your price is not the second highest price, your protest will get kicked out unless you can convince GAO that everybody else in between you and the awardee on price should have also been kicked out of the acquisition. So consider the agency, consider the acquisition. The final piece that I will mention, I'll call this check the office politics. Now, what does that mean? I hear a lot from clients that say, oh, I don't want to get blacklisted, which is not a thing, but sort of a thing, and nobody really knows if it's a thing. I don't want to make the contracting officer mad. I don't want to make the agency mad. Those are valid points, but I think in many cases, particularly for smaller entities, are overstated, right? Most of the contractors will deal directly with the project team. You talk to the CO or you meet with the CO to sign a mod to a contract that you and the project team on the government side have worked out. You don't have a lot of lengthy discussions with the CO. You don't have a lot of face time with the CO, but it's the CO that is the government's agent for purchases. The CO by law makes the decision who is awarded the contract. You know, the CO makes that decision with input most times from the source selection advisory committee or whatever the name is it is, and those folks are technical folks, but it's the CO that makes the decision. So what's the relationship between the people that you're in with and the CO? How is a bid protest going to, I guess, be presented within that relationship? Is there a battle going on between the CO that mandated a particular choice and the project team that really wanted somebody else? Another potential relationship, which you never know until after you start the protest, but you need to keep in the back of your mind, is how deferential is the legal team to the CO? The legal teams that I deal with, they all call the CO their client, which means that the client directs the course of responding to the bid protest, but their level of deference to the client may be different agency to agency. And then finally, this is what I ask every one of my clients when they're thinking about protesting: what's really going on? What do they think is really going on? And you can almost never protest on the grounds of what is really going on, but a bid protest is by its very nature a request that the agency change what it has done based on a set of almost always incomplete information about what the agency did. So your goal in deciding whether you should protest or not is to get as much information as you can. Find out what's really going on to the extent you can, even if it's not a direct factual or legal basis for a protest ground. That is the 5 items. With those 5 items, you can oftentimes make a much better informed decision about whether to go or no go on a bid protest. Bid protests are complex. They are based on incomplete information. They have tight deadlines, and the relief you end up getting is complex and shifting and not always exactly what you're expecting. Your goal when trying to decide whether you should submit a bid protest is get as much information as you can and simplify the field that you're playing on mentally in terms of your analysis. Simplify it as much as possible. Use this checklist, use other checklists and quick check items to figure out as quickly as possible, and with frankly not always complete information, whether you should file the bid protest or you should not file the bid protest. Thank you guys very much for your time. And Jennifer,
Thanks, Chris.
Turn it back over to you.
Super. Thanks so much for the great information on bid protest. If anybody has questions, Chris's information is there, phone number and email address. Tomorrow we are covering the Mentor Protege program and Friday contract purchasing review system. The following week we've got, or the following weeks we still have additional topics that we're covering in government contracting, and today's webinar will be posted on our website probably after 5 o'clock today. So thanks again everybody for joining us, and hope you'll tune back in for some of our future webinars.